Welcome back to another Tuesday Tips at 2 with the Goldbergs. Do I have your permission to remove this mask? La Directora, audience? Yes. Sweet liberty of breathing freely. How's everyone doing? All right? Still employed? Healthy? Living well? Still love your spouse? Children? Well fed? Did you pick up a hobby? Did you learn another language? If not, what have you been doing with yourself? On our end, we've been working pretty diligently. You've probably seen some of our marketing materials for the mywillnow.com website, and it's been going pretty well in terms of people signing up and doing the responsible adult thing. Speaking of which, what's your excuse? But that's not what we're here today. We're here to talk about blame. Some people might blame this whole corona disaster on the Chinese Communist Party. Others might focus on local domestic politicians, and yet others might blame God, etc. I personally have my views, but for the purpose of today's conversation, we're going to be thinking about how does blame for an unforeseen event lay in within contract law. Believe it or not, there is still litigation going on out there. While the courts are still closed, people are still filing lawsuits. And the lawsuits these days are all tainted by this coronavirus that's actually happening. And it's impacting people's ability to perform on their contracts. In a previous Tuesday Tips at 2, we discussed what to do if others owe you money and what you should do if you owe people money or companies money and how to handle that. Underlying that premise is there isn't sufficient amount of money to pay off contractual obligations despite there being a contract. Why? Well, the pandemic is here, economic downturn. I couldn't. I wanted to, but I didn't have the opportunity. So within the world of litigation, the big new wave coming on up is going to all relate to this. And a specific doctrine called Force Majeure. Now, it's a French term, and I hope that I didn't butcher it up. And if I did, please don't point it out. Force Majeure is a doctrine brought up by defendants that are being sued for breach of contract, where the plaintiff says, we had a contract, we had a deal. You didn't perform your end, even though I did mine. I paid for the service of the good, I didn't get it. Or I provided the service of the good, and you, defendant, did not pay me for it. And the defendant says, whoa, force majeure. I wanted to, but I couldn't. Wow. The concept of force majeure came about within contract law for a basic reason. As a new buddy of mine named Zach Wolf, who writes 5 Minute Law, a blog post, pointed out and explained so well, the concept of contract law really is an apportionment of risk. I contract with someone else to do something or to give me something in exchange for a price. And there is risk that it goes wrong for both of us. There's risk that perhaps I, after signing the contract, find a much better deal out there for far lower amount of money. Tough cookies. I still sign the bottom line and still owe the money. Ditto from the other side. The other side might have said, all right, I will commit to doing this service or selling you this product in exchange for this amount of money, and then quickly learn that someone else was willing to pay a whole lot more. Tough luck. He still has to perform. The risk was taken at the time of the signature to say, this is what we want to do. But force majeure says, forget risk. Something else occurred in the middle. An act of God, an irresistible force. The definition under Merriam-Webster is a superior or irresistible force, meaning something that could not be stopped. Now, of course, there are plenty of examples on over here that we know of locally. Here in Houston, hurricanes occur. They're real. That's a real problem. And so the risk of a hurricane coming and imposing itself within a contract is something that often parties within Houston might say, hey, force majeure, you can't blame me that I didn't perform. There was a hurricane. Of course, Built into force majeure isn't simply that something occurred that blocked a party's or a defendant's ability to perform, is that it was something that was likely just unforeseen and unforeseeable, that you couldn't plan for it. So if a hurricane strikes in the middle of our heartland, like Colorado, a landlocked state, well, that's a pretty good argument. No one could foresee that whatsoever. However, if an avalanche in Colorado knocks out a 18-wheeler that's delivering some product and it doesn't get to its destination by the promised date, the plaintiff might still have an argument to say, look, this was foreseen and foreseeable. You had the opportunity to ship me whatever products in your 18-wheeler before the storm or after the storm. You screwed up, the risk is on you. Similarly, an avalanche on over here in Houston would probably qualify as force majeure, a excuse to performance, but a hurricane might not. Because a hurricane, after all, does occur on over here, and the contracting parties probably should have thought that one out before accepting the risk of delivering a service or product by XYZ date for this or that product, for this or that price. So, how does it all play out in the age of the coronavirus? The truth is,
nobody knows but Jesus.
Nobody knows. In the political arguments right now, there's finger pointing over who's to blame and what could have been done and how foreseeable it was. With some out there, like Bill and Melinda Gates Foundation, having really called the siren on this to say this is a real risk. And yet for everyone else, no one acted, no one prepared, because no one really expected a once in 100-year pandemic to strike. So now, if a party cannot perform, for example, I run a manufacturing plant and I have committed to delivering XYZ product by this or that date across international boundaries. But oh no, my plant is being forced closed by local health officials and international travel is completely cut off. How can I perform? That's a great excuse if that entity is sued by the plaintiff to say, you promised me this by this date, but you didn't deliver. Great excuse. How will it play out? The truth is nobody knows. Case law on this issue recently has been sparse because this hasn't percolated to, let's just say, the levels that this pandemic has. So there have been some good cases about it recently, which will be discussed. I, along with my new buddy, Zach Wolf, along with Tina Nguyen, on August 21st at an HBA CLE, where we will be the panel. I've been invited and quite honored to be invited, especially since I'm not all that smart. I think it's just my dashing good looks and maybe it's my great hair, to host a panel about force majeure. And we're going to be discussing the implications of recent case law and the existing situation and how this might play out. Either way, there's going to be a ton of litigation in the upcoming future where a ton of contracts are not going to be fulfilled in one way or another. And defendants throughout the entire country are going to be saying, it's not my fault. It wasn't foreseeable. It was an act of God, force majeure, that prevented me from doing this. Whatever happens between now and then, I'll be prepared for that. And I'm hoping that you will stay safe. I'm hoping that you will return back to work. I'm hoping that the business that you're engaged in will thrive and be able to succeed and stay alive and keep everyone employed so that everyone may put food on their family's table without having to resort to governmental handouts. These are tough and trying times, and whether or not you side with reopening the economy sooner or later, I'll tell you one thing, I loved getting my hair cut right now. Super excited about that. Until the next one, Tuesday Tips at 2 with the Goldbergs. I will see you, and I wish you nothing but health and success and a little bit of happiness on your home front. Take care.